Hello friends, in the series on the income tax cases, today we will discuss a very important issue on section 264 revision applications. Section 264 gives an option to the assessee to file revision application against an order with the Principal Commissioner of Income Tax if he chooses not to file appeal against that order. The prime condition is that the assessee cannot opt for both the options. That is, at the same time, the assessee cannot go for appeal and at the same time for the revision application. This issue has been taken up by the Allahabad High Court in the case of Ratan Industries Limited versus Principal Commissioner of Income Tax and another, and the case is reported in 460 ITR at page number 504. The date of the judgment is 11th May 2023. The assessment year relates to assessment year 13-14. In the present case, the facts are very interesting. The assessee was issued a notice under section 148. The assessee filed a writ petition in the Allahabad High Court saying that this notice is not valid, it is out of jurisdiction. The court said that in the present writ petition, by admitting the writ, that the revenue authorities are free to go ahead with the assessment proceedings until and unless the decision of the writ court comes. The revenue continued the assessment proceedings as per the direction of the court and passed the assessment order against the assessee. When the assessment order come under section 147, this time the assessee filed a revision application under section 264 with the Principal Commissioner of Income Tax in spite of filing the second writ to the court or filing the CIT appeal. When this application came for hearing before the learned Principal Commissioner of Income Tax, he was of the opinion that since the assessee has gone to the writ court against the notice issued under section 148 in the Allahabad High Court, so he said that writ of the assessee against the notice under section 148 should be treated as appeal, and since the appeal is pending in the Allahabad High Court and the decision has not come, so he is not able to entertain the revision application under section 264. So he rejected the application of the assessee under section 264 on the ground that the assessee appeal is pending before the Allahabad High Court. When the Principal Commissioner of Income Tax rejected this revision application under section 264, the assessee filed writ against this rejection again in the Allahabad High Court. Now the moot question before the Allahabad High Court against the second writ of the assessee was that whether the Principal Commissioner of Income Tax was correct in rejecting the revision application on the ground that the appeal was pending before the Allahabad High Court in the form of first writ of the assessee. The court was of the opinion that the writ filed by the assessee cannot be equated with the appeal of the assessee, and secondly, the Allahabad High Court was of the opinion that since in the first writ filed by the assessee, the court has directed the revenue authorities to proceed with the assessment and not to stop the assessment proceedings, and since the assessment order has come, so the first writ of the assessee has become practically infructuous. So the court said that in the present case, the Principal Commissioner of Income Tax has erred both in facts and law by treating the revision application invalid on the ground that the appeal of the assessee is pending before the Allahabad High Court. So in this judgment, it can be concluded that the revision application cannot be rejected on the ground that the writ of the assessee is pending in the High Court, especially in those cases where that writ has become already infructuous because the assessment order has been passed. Friends, this case is very important because the assessee has an option to go to the Principal Commissioner of Income Tax against the assessment orders. And since in the CIT appeals, a lot of time consuming process is there, the decisions are not coming, so the assessee can think of going to the Principal Commissioner of Income Tax. At the end of this video, once again I am repeating the name of the case. The name of the case is Ratan Industries Limited versus Principal Commissioner of Income Tax and another. This case has been reported in 460 IPR at page number 504. The matter has been decided by Allahabad High Court and the date of the judgment is 11th May 2023. Thank you, friends.